Overall, I'd like to say that we welcome the introduction of the draft legislation with qualifications. There are a number of features of the new legislation which we have long called for and which we welcome. But in summary, there are also some significant shortcomings and drawbacks which we have pointed out with previous iterations of anti-hate speech legislation, and we're concerned that those have been preserved to some extent in the current round, and we are concerned that if they are not addressed and rectified, that we're going to be back here again in 2 years or maybe even sooner, wondering what went wrong and why we have to go through yet another round or another set of iterations of this legislation. I'm happy to go into the detail of what we consider to be the shortcomings as well as the positives, but I think that's the kind of the high-level introduction that I would like to give you, and given the shortness of time.
I appreciate that. Anita, did you have an opening statement or any remarks you'd like to make? Okay. Look, I might just ask a couple of questions and then I'll hand over to the opposition. And look, just in light of your statement and earlier public comments that you have made, is it correct that the Executive Council of Australian Jury's position is that there is a need for the Commonwealth to strengthen its hate speech laws?
Yes, we do say that, and that's a position we've consistently held publicly and before parliamentary inquiries going back at least to 2010. And the need for such legislation has been highlighted not only by the anti-Semitic terrorist attack that occurred at Bondi Beach last month, but also the climate of hatred that preceded it.
And it's fair to say you have been calling for some time, well before the attacks that occurred late last year.
Yes, I mean, you can go back to 2024 when the criminal code hate crimes legislation was introduced. We made a detailed submission to that parliamentary inquiry. I've forgotten the exact committee, but again, we pointed out that while some of the new provisions that were introduced at that time were welcome, there were still significant shortcomings, and in particular we pointed to the absence of a serious vilification provision that had previously been mooted but not included in that bill. So that was just the last occasion, but you can go back to many occasions even prior to that when there's been consideration of anti-hate crimes legislation and amendments to the existing legislation, and we've made similar points.
Moving to the exposure bill, and particularly to the aggravated sentencing factor, what are your views on this provision?
Look, you're talking about the aggravated sentencing provisions for ordinary, what might be called ordinary crimes that that have a hate motivation as a factor.
Particularly, and maybe this might help you with your response, but your views on it being targeted only to race,
yes,
ethnic or national origin as the protected attribute.
Well, as a general proposition for the entire suite of provisions that are contemplated, it's long been our view that the protections that are contemplated for race should also be available for individuals who are the subjects of hate crimes or the promotion of hatred on the basis of other inherent attributes such as sexual orientation, gender identity, age and disability. I think religion is a bit of a question mark because it's not so much an inherent attribute as it is a set of beliefs. It's a bit of a grey area, that one, and I think that needs perhaps a little closer consideration. But certainly with the other attributes that I've mentioned, which are inherent attributes, to attack a person for who they are, in effect, is something that I think should actually attract enhanced penalties and should be considered as an aggravating factor.
Regarding the new racial vilification offence, does the Executive Council have, I think, has previously raised some concerns with the standard of proof being intention as opposed to recklessness? I just wanted to understand a bit more why you've come to that viewpoint.
Well, originally we were prepared to consider an offence that was limited to intention as the mental element. That was about this time last year when the bill was a bill was introduced to that effect by Allegra Spender MP, and we supported that bill. And we were prepared to live with an offence that was limited to intention as the mental element. Since then, of course, we've had the events at Bondi Beach and the events and also the events that preceded it, the climate of hatred and vilification that preceded it. And so we think that setting the bar at intention would be too high and would not capture some egregious examples of hate speech that we think should be captured. I mean, just to give you we can give you some specific examples in our written submission, which we're going to provide to you by close of business tomorrow. But in my own discussions with the government and with departmental officers of various departments, it's been put to me that setting the bar at intention could actually exclude a lot of antisocial activity that ought to be covered. And the kinds of speech I'm talking about is where somebody says something that is subliminally and indirectly alluding to the promotion of hatred, but doesn't quite get there to the point of establishing an intention to do so. But there's clearly an indifference amounting to a reckless indifference as to whether it has that effect. And we think that that should be captured because very often bad actors out there are well aware of the law, they're well aware of the limits that they can go to, and are prepared to push those limits to the absolute extreme. And unless you have a recklessness element, which is usual for criminal offences generally, they'll be able to essentially get away with that sort of strategy.
Yeah, I appreciate that, because I mean, I also wanted to ask though, then what's your view on the inclusion of the religious text exemption?
I'm totally opposed to it. We think that that is a completely misconceived provision, and we've made that very clear in all of our discussions with government. It won't come as a surprise to anyone that we think that that is totally misconceived. The exemption would be for anything that quotes or references religious texts for the purposes of religious teaching or discussion. Now, we think that the entire concept is misconceived and outdated, because none of the world's recognised religions would openly avow to promoting racial hatred intentionally, knowingly and deliberately. They might say that some of our texts have been and can be misinterpreted in that fashion, but people might quote from a religious text and inadvertently give the impression that they're promoting hatred. But that is not what the texts actually mean. And all of the recognised religions would disavow any suggestion that they are intentionally out to promote and stoke racial hatred. So if that's the case, and given that intention is such a high bar to prove as the mental element, then there's no justification for having that exemption there, because in any circumstances where say, a cleric might give a sermon about something that might be interpreted as promoting racial hatred, that would not be covered by the offence because of the intention requirement. And where intention is proved beyond reasonable doubt, which is the highest evidentiary standard, then of course that would be caught by the proposed section, and we would say it should be caught, because the intentional promotion of hatred is not really something that ought to be protected under any circumstances, including using religion as a cloak. And the major authorities of each religion would tell you in any event that that's not what their religions teach. In fact, it's the exact opposite of what their religions teach, because it's so inconsistent with their basic principles about the sanctity of human life and the inviolability of human dignity.
And as it's currently drafted, do you think that the provisions then, would you seek any amendments to it? Too broad? Just remove the provision?
Just get rid of it. We would say that provision just does not belong there. It doesn't belong there because it suggests that somehow one can intentionally promote racial hatred and do so intentionally within the bounds of religious doctrine, and we don't believe that to be true. And to the extent that it is true, it's not a justification.
Yeah, and
not
I think
for intentional promotion of hatred. I'm sorry.
That's all right. And I was just going to say, though, in just to add to what you said, I guess the response after the horrific, anti-Semitic attacks and terrorist attacks that occurred, some probably have argued, and there will be some as part of this process through this committee, that such provisions should be there to capture some of this hateful speech. But I just wanted to really understand then, so ultimately what you're saying, that the bill should really focus just at the race, ethnic or national origins, as you had indicated a bit earlier, rather than this religious text?
Yes, I mean, let's just put this in context. I mean, the bill as it is would proscribe the intentional promotion of hatred on the basis of race. So on that assumption, is there any justification for exempting so-called religious discussion? And to the extent that a religious discussion or any discussion involves the intentional promotion of hatred on the basis of race, we would say it should not, in any event, it should not be captured and it should not be exempted. But in any event, most religions are saying that this is not what they are teaching, this is not the intention of behind them. And where a prosecutor is unable to establish that intention, then the question won't even arise in the first place. But where there is evidence of intention to promote and stoke hatred on the basis of race, then religion is no excuse.
Yeah. I'm mindful of my time, so I'll just be quick with the last remaining questions. But I just want to ask, does the Executive Council support the increase then in the maximum penalties for existing hate crimes offences in the Commonwealth Criminal Code?
We do, but we also believe that it's necessary to introduce mandatory minimum penalties for the whole range of Division 80 offences. And I might let either Simone or Anita or both address that in more detail.
Okay. Before we do that, I'll also ask this other question then. Do you have any views then about the new listing regime for prohibited hate groups? Like, do you believe there's enough safeguards in place before a group can be listed?
Yes, I think that is one of the positives of the legislation, and we have welcomed that. We've been mindful of the fact for many years now that there are groups out there that act to promote hatred and to stoke it and to exploit it for the purpose of inculcating extremist attitudes and behaviour among some of their followers, but they fall just short of the requirements needed to list the organisations as terrorist organisations under the current provisions of the Criminal Code. Again, this goes back to these sort of actors becoming increasingly sophisticated, getting legal advice about how far they can go and so on. So having a secondary regime to capture extremely antisocial behaviour that falls short of what is necessary to list an organisation as a terrorist organisation is a good step forward, and we welcome it. And I think there are sufficient safeguards in it.
Okay.
Yeah,
now, Simone, did you want to add?
Yeah, I think it is the right step forward, and it's something that ECAJ proposed, I believe, in 2021, so well prior to kind of this recent uptick in hate. However, the bill at the moment requires an assessment around, the potential commission of a hate crime. And I guess what we would say is that if an organisation expressly or by necessary implication in its objects promotes the hatred on the basis of a protected attribute, then obviously that should in and of itself mean that the organisation should fall within the listing regime. There should not need to be an assessment as to the likelihood of the commission of a hate crime, because if an organisation is inculcating individuals in Australia and promoting hatred in that way, then logically that really should mean that it falls within this new regime.
Anita, did you want to add anything to any of the questions I asked to the Executive Council?
I would just add, in respect of the increase in penalties for Division 80 hate crime offences, that the ECAJ office would repeat and endorse the recommendation made by ECAJ at the start of 2025, that those offences also have a fault element of recklessness rather than intention, so that they operate effectively. Of course, if the existing Div 80 hate crime offences aren't capturing the relevant conduct, then an increase in penalties would be to no avail. Having said that, of course, we would support any increase in the penalties for those offences because they are very serious.
Is there anything else around the world that you've seen that we might want to consider that's been effective in terms of other provisions?
Canada, I think.
Yeah, Anita, do you want to speak to Canada, and then maybe I'll speak to the UK?
In ECAJ's submission to the recent New South Wales review conducted by the Honourable John Sackar, ECAJ made some comments with respect to the Canadian offence of the willful promotion of hatred. That offence differs slightly from the current Commonwealth proposed offence in that it does not include any requirement to cause intimidation or fear. And it includes a form of good faith defence with respect to religious discussion, but not in the breadth of the current exemption. The Canadian government has actually announced its intention to remove that defence for genuine religious discussion. It's not been successful in the several decades of its operation. More broadly, our office would point to the Canadian offence as illustrating the fact that the threshold of hatred, and in particular the intentional promotion of hatred, sets a very high threshold, and that there's no need for additional requirements, in particular the requirement to prove fear within the offence. The offence already captures a very narrow scope of conduct, and that's illustrated by the Canadian offence.
All right. Now, I'm going to hand over to the Deputy Chair and then Senator Duniam. Deputy Chair, you have the call first.
Thank you, Chair, and thank you so much for all your attendance here. And I know it's been a very quick turnaround, and we've seen other experts not be able to provide evidence because of that turnaround. So I just want to say thank you. I heard your views around the bill that allows the defence for quoting religious texts, but do you agree this could be exploited by hate preachers to justify anti-Semitic rhetoric?
Yes, in fact, we have the evidence of the case of which I brought together with one of my colleagues last year in the federal court against Wissam Haddad. Mr. Haddad has has not denied having a history of association with some notorious people in Islamic State and also in recruiting young men for extremist activity. So that was the background. But he had made a number of sermons, I think they were characterised as, in November 2023 to a prayer group of up to 200 people. And those sermons had included a number of statements involving derogatory generalisations about Jewish people. And in the course of that, he had referred to or quoted certain religious texts and then extrapolated from that justified hatred against Jews generally. And he made a number of assertions to that effect. The court, we took him to court under the provisions of Part 2A of the Racial Discrimination Act, which of course are civil provisions, not criminal. But in the course of the trial, he sought to argue that he was simply quoting from religious texts and exercising his religious freedom and so on. And the court, of course, did not accept that argument. And ultimately, he was found to have contravened the anti-racial hatred provisions of the Racial Discrimination Act and certain injunctions and other declaratory orders were made. And that was that was the end of that particular proceeding. But the significance of it is that the defence of citing religious texts was raised in that context. And whilst it was dismissed in the context of civil proceedings, if a similar sort of excuse were to be raised in the context of criminal proceedings where one has to prove intention, and one has to prove it beyond reasonable doubt, I think a prosecutor might well be deterred from the obvious course of prosecuting such statements in the context of this proposed legislation if it came to making a decision, because they would possibly come to the conclusion that with that exemption, there could be no certainty of success with the prosecution, and that the defendant would merely have to state that they were quoting from religious texts and demonstrating that, and it was in the context of a prayer meeting, and that'd be the end of it. It would escape. I think it would escape prosecution, and even if there was a prosecution, it would possibly fail with that exemption included.
So Peter, just so I get some clarity, can you confirm you believe Wasim Haddad would be protected by this exemption?
I think if the identical circumstances arose with Mr. Haddad, there is a significant chance that he would escape liability under this section, and for that reason, probably escape even the attempt of prosecution.
Thank you. Do you believe that everyday Jewish Australians would feel protected knowing this defence exists?
I think it would cause great consternation, and has caused great consternation based on the feedback that we've received, that this is a very wide loophole that would be exploited to render the introduction of this offence ineffective.
Peter, were you consulted about this exemption before it was announced?
Well, I don't want to go into confidential discussions, but it's no secret that these sorts of issues have arisen in the past, both in the context of the current legislation and in the context of equivalent legislation in New South Wales. And so these are not new issues, and our views, as Anita pointed out, were placed very forcefully before His Honour Justice Sakar, who has done a report in relation to the relevant provisions of the New South Wales legislation, and that report has not been released. So we don't know what it said, but our own views are very clear. The government was well aware of them, and I don't think I need to go beyond that.
Are you aware of any other Jewish peak body that supports this exemption?
No.
And were these discussions confidential in nature because that was how it was described to you, or were you providing feedback on an exposure draft that you were allowed to see?
Well, again, I don't want to go into the detail, but it's not unusual for governments that are contemplating introducing legislation that might have a particular impact on one section of the community to consult with them beforehand, even with exposure drafts, and to seek their views. So that would have been entirely unexceptional. And again, I'm sorry if I sound a bit vague, but I don't want to breach any confidences here.
Peter, you're not vague, mate, and I'm just trying to, it's been a quick turnaround for us to see it as well. I'm just trying to do my best with trying to understand what you've gone through, how you see this as well. And I don't mean to use this language, but I think I have to, and I'd like your opinion of it, but I just want to give you a warning that it's probably not language that you're going to like. Do you believe terms like globalise the Intifada and death to the IDF will be prohibited under this bill?
I think it would be a moot point. I think they should be prohibited under this legislation. But because, I mean, what globalise the Intifada, I mean, the broad Australian public may or may not be aware of what that really means. The Jewish community knows exactly what it means because during the Intifada, suicide bombers were sent into Israel. They blew up civilians on public transport, in supermarkets, at discotheques. There was even the shocking case of a 15-year-old Australian girl who was Malky Roth, who was blown to pieces in a pizza parlour in Jerusalem. So we know exactly what Intifada means, and to say globalise the Intifada means spread it around the world and bring it here to Australia. And we think that is promoting hatred, and we think it's intentional promotion of hatred in most contexts, and therefore it should be proscribed. But I'm not sure that a prosecutor not having that knowledge and that background would necessarily understand that. I'm not sure that a court would understand that. So it's difficult to predict what the outcome would be if a prosecution were to be brought about that. And the same, with death to the IDF, I mean, on the face of it, it just seems like a slogan about the Israeli military. But when you understand that it's being used in protests and to justify violent actions against Jews, not in Israel, but all around the world, it has a meaning that might not be apparent to an uninformed observer.
Yeah, Peter, the reason I ask is because yesterday a departmental official couldn't answer whether the Intifada slogan was captured or indeed whether a fatwa was a religious text. Does that concern you, that a departmental person can't answer this?
Well, look, I think it's a concern because it's indicative not of a level of ignorance of a particular departmental officer, but I think a generalised lack of understanding and lack of insight by people who are not as intimately concerned about that particular conflict as those who are directly involved. I think it's just human nature that you tend to be more knowledgeable about the things that are closer to home and less knowledgeable about things that affect other people. And that's really what I'm concerned about, that given the fact that 99.6% of the Australian population are not Jewish and probably have only a very generalised understanding of the context, that the meaning will not necessarily be properly understood even by a well-informed court.
Yeah, and I agree. And, mate, I only ask because if the people who wrote the legislation can't explain it in its operation, how can we consider it properly? But I just want to say thank you for your time, and Chair, I pass over to Senator Dunningham.
All right, thanks. Deputy Chair, Senator Dunningham.
Thank you, Chair, and thank you all for your attendance today. In general terms, I just want to get a sense, perhaps starting with you, Mr. Wertheim, and putting aside the exemption that is in the proposed bill, the exposure draft, do these laws do what it is the community you represent want them to do? Is that your belief at this point in time based on what you've read?
Well, overall, we'd rather see the current round of legislation passed than not passed if it came down to that stark choice. But that's not to detract from anything that any of us have said about what we see as the current shortcomings in the bill. As I said at the outset, I just don't want us to be here again in 2 years' time talking about the next round of legislative amendments to fix up all the problems of the previous attempts that have been made by the Parliament to address this problem, when we can quite clearly fix all of those defects now. We can identify them now. This is not a new set of issues, even though the bill is new and it's being done on an urgent timetable, understandably. The issues that it raises are well-worn ground for all of us. We've all been debating these issues with previous iterations of this legislation going back for 15 years or more. So we'd like to see what we perceive as the shortcomings of the current bill fixed up in the light of that history and passed. But if we have to just take what is on offer now rather than nothing, I think we will take what's on offer now.
Well, and to that end, I suppose as an opposition, we've made it clear that this should not be a take it or leave it proposition, and that it is important to ensure that we get this right. And there's a range of stakeholder groups who've said there are changes that need to be made to this legislation in various ways, a number relating to the exemption we've already talked about. But forgive me, I'm not completely familiar with all of the suggestions that ECAJ have made to remedy the issues you've identified with the bill. But, I mean, you know our timeline. At this point in time, we're returning here on Monday for the necessary condolence motion, and then on Tuesday to debate the legislation and pass it in pretty short order. I mean, would it be better, because as you say, you'd rather not be here in 2 years' time fixing up what it is that we didn't get right this time round, perhaps because we've rushed it? Is it better that we try and take our time to get the elements of the legislation that need fixing now right, instead of just passing it as is?
Well, we will have a very detailed submission to you by the close of business tomorrow, and I'm sure Anita can give you a timeline on a SECA's submission. You'll have all the detail about where the defects are as we perceive them and what is needed to be done to rectify them. So when you say, should we be taking this more slowly, there is I think a legitimate urgency about this legislation in view of recent events. And I don't think that it should detract from the capacity of the Parliament to deal with the bill effectively. As I said, these issues are not new. We have traversed them before with previous rounds of legislation. We can deal with the relevant shortcomings in relatively expeditious fashion. And I think now is the time to do it. And of course, we would love to see the bill amended in the way that we have been proposing and will propose in detail in our written submission.
Yeah, okay. Ms. Stucken, did you want to add anything to that?
No, the office will also put in a submission before the deadline close of business tomorrow.
Okay, well, I won't ask you to run through, either of you, what the elements are, given the shortness of time, and we will await those submissions with interest. I guess it is a hallmark of this process, which is extremely truncated for good reason, but also it does make doing the job here very, very difficult. I do think we need to do our best, and that's our intention. Again, some of the evidence you may have seen yesterday, and Mr Thompson referred to it, the department unwilling and for good reason unable to provide hard and fast answers about what would be caught, what would not be caught. I mean, I accept your point, Mr Wertheim, that the majority of Australians wouldn't know what the slogan "Globalise the Intifada" means, but you and your community do, and it is said with often, I believe, with an express purpose to instil in you a particular feeling, hence what we're talking about here. The officials yesterday kept saying, well, it's a matter for the courts. And so you talked about the inclusion of the intent threshold or demonstrating intent. I mean, that's a concern you have. Can you just step me through that a little bit more so I understand what the alternative would be from ECAJ's point of view?
Well, the alternative is to treat the offence in the same way that other criminal offences are treated, and that is to have a mental element that encompasses either intent or recklessness. That's the short answer to your question. And I think if the legislation were amended to include a mental element of recklessness, it would lose very little in terms of its public acceptability or whatever the concerns may be at setting the mental element so high. And it would also significantly enhance the potential effectiveness of the legislation to do the job that it is purporting to do.
Okay. Yeah, and I think the way that it's framed currently as well with an inquiry into the reasonable targeted person is problematic, because the focus should really be on the commission of the offence rather than on how it makes the targeted community feel. And what it does is it adds an extra prosecutorial burden, and it means in practice, as we've seen with the civil provisions, that you know, it becomes an inquiry that may elevate fringe perspectives.
Okay. That is very helpful. In general terms, the structure of the bill, it's an omnibus bill that contains a range of measures that relate to hate speech, hate groups being listed, firearms laws. I mean, would it be the preference of ECAJ to have the bills separated, or you don't mind? I mean, to us, given the complex nature of everything we're dealing with here, it was an odd inclusion, but does your organisation have a view?
Yes, we're certainly not experts on gun control laws, and we wouldn't in any way seek to express a view about that in this inquiry. I mean, we're just not qualified to speak. We don't have any particular insight that we can bring to bear that might aid the committee. So conceptually, we see them as two completely different sets of provisions, and so it might be better to deal with them separately, but I mean, we don't have a particular view, you know, a hard view on that particular issue, or frankly on anything to do with the gun control issue, because it's not something we feel qualified to speak to.
Okay, thank you for that. Ms Stucken, I just wondered whether the proposals contained in the bill had been seen by the Envoy's office in any way, given the work of the office, prior to December 14 last year.
I apologise, may I ask you to repeat the question?
Yeah, so my question was whether the Envoy's office had seen the proposals like the ones that are contained in the bill we're inquiring into here, or the draft bill, prior to the 14th of December, prior to the terrible day in Bondi last year.
Look, I would suggest, as Peter mentioned earlier, it's best that I not speak to any confidential matters between our office and between the government. Perhaps I could take that question further on notice.
Yeah, but if you could, I guess I'm just trying to understand whether these proposals, so perhaps the question on notice could be when the Office of the Special Envoy first became aware of provisions like these contained in the legislation as we have it here, the bill as we have it here today, and then that enables us to understand whether these were in contemplation prior to what happened in Bondi or as a result of. And perhaps I might ask the same question, if need be, on notice of ECAJ as well.
Well, I don't think we need to take it on notice. I mean, we did do a submission to the Senate Legal and Constitutional Affairs Legislation Committee in 2024 on the Criminal Code Amendment Hate Crimes Bill of 2024.
Yes.
And there were a suite of measures in that bill which we commented on. And as I mentioned earlier, conspicuous by its absence was a provision in relation to the promotion of the intentional or reckless promotion of hatred on the basis of a protected attribute. And our submission dealt with both what was in that previous legislation and also what was absent from it. So I think you can, I mean, if you're asking the question about provisions like those that are in the current bill, I think that's the best answer we can give you.
And that was at the end of October last year. So, you know, this was already, consideration of these matters was underway and has been underway over a long period of time. And in that submission, you'll see we put forward what we perceive to be a solution in terms of what potential legislation could look like. And of course, it was not passed.
Yes, of course. And so just on that, I mean, you've provided the submission and it covered omissions as well as inclusions. So are you aware whether, or had you been consulted on a set of provisions that might cover that issue prior to December of last year? I mean, you've referenced October last year, but was anything provided to you for your views?
Well, as a consequence of the absence of any similar provision in that 2024 bill, we advocated for the introduction of such an offence, and that ultimately found expression in the bill that was introduced by Allegra Spender MP, I think it was February 2025, and it contained a provision like that. And we are on record as having endorsed and supported the introduction of that provision at that time. So that's a year ago.
Yes. Okay. All right. Thank you for that. My final question I have here, is there any view or any concern held that the bill lacks a specific definition of anti-Semitism or provides any examples that might guide those making decisions adjudicating over matters that might need to be considered? Is there a concern around that? I'm sure you'll touch on it in your submission.
Well, I guess there are two separate questions. One is, should the bill itself contain such a definition? And I'm not sure that would be appropriate because we're talking about a general offence of promoting hatred on the basis of race. Sorry. A general provision to proscribe the intentional promotion of hatred on the basis of race. So it's not just about anti-Semitism, it's about promoting hatred against any group on the basis of that characteristic. And there are other groups from time to time who would need to be protected by such legislation. So it would be, I think, out of place in the legislation itself to have a definition of what constitutes hatred against any one particular group. Having said that, though, I do think it would be appropriate for police and law enforcement agencies generally to have some guidance about how the provision might operate in relation to the protection of particular groups, including the Jewish community. And in that context, I think it would be very useful to have a definition of anti-Semitism there as a guide. And we're all aware of the International Holocaust Remembrance Alliance working definition of anti-Semitism, which is not a kind of a definitive definition, but an illustrative definition. That's why it's called a working definition, which would be there precisely as a guide and as an aid to law enforcement agencies in working out how to apply the legislation. And in fact, that is the process that has been adopted in the United Kingdom. The Crown Prosecution Service and the police have from time to time published guidelines about what constitutes anti-Semitism for the purposes of enforcing similar legislation in the UK.
Okay, thank you very much.
Canada has also produced a handbook in which it outlines the application of that definition to what's called illustrative examples, real life examples of anti-Semitism. So there's a lot of guidance out there.
Okay, thank you.
Thanks, Senator Dunham. Now, I understand, Senator McDonald, do you have some questions? And then we'll have to keep moving along.
Thank you very much. Good afternoon to you all. Thank you for making your time available so quickly today. I wanted to just go back to part 5 and the racial vilification offence. I asked some questions yesterday of the department around in the subsection. They classify that the expression of race, colour and national or ethnic origin should be taken to have the same meanings as in the Racial Discrimination Act. I just want to, again, double check that you are satisfied with this as a clarification because, we know that Jewish people don't all have the same hereditary characteristics or whatever. And I just want to be very specific that we're not missing something here and would like your views on it, please, Mr. Wertheim.
Certainly. Yes, it's a fair question. It's one we're asked quite frequently because, I mean, the word race can mean a lot of different things. In past times, it had sort of a biological meaning and was interpreted as you put it earlier, as inherited characteristics. Well, there are, Jews are not a race in that sense. And despite, Nazi ideology and shocking medical experiments trying to prove to the contrary, they all failed. There is no biological identifier or anything of that nature that would identify Jews as a group. But the word race in the context of anti-discrimination legislation has a very different meaning. It means a group that has a shared past, shared history, shared culture, language, and other ethno-cultural identity that is accepted both within the group and more generally by other people in society. And in that sense, it has long been established in the jurisprudence of Australia, New Zealand, Canada, the United Kingdom, and the United States that Jews are an ethno-cultural and ethno-religious community in that broader sense and are therefore protected under the rubric of the word race in anti-discrimination legislation.
Okay, so I then extended it in my questions about whether that protection would be applied to other groups and, specifically Christians, Catholics under that group. You made the point earlier about thinking that this legislation should be expanded to include other groups of inherent characteristics, gender and, I'm sorry, I've forgotten the exact list that you used. But, by using this definition, are we Are we allowing for some religious protection and not others? And I'm curious to get your views on that.
Yes, so under this legislation and similar anti-discrimination and anti-hate legislation, Jews are not protected as a religious community, they're protected as an ethno-cultural community. It's a little difficult for many people to understand that the Jewish community is not just a faith community like Catholics or Muslims or Buddhists. We're also an ethno-cultural community with a long national history, a long history of self-government and state institutions, at times state sovereignty and so on. So that Jews are an ancient people with, and our identity is defined in terms that made sense in ancient times and have been carried forward into modernity. It's a holistic identity. It's not compartmentalised between religion on the one hand and culture and ethnicity on the other. And it's for that reason that communities like the Catholic community or the Muslim communities or Buddhists or Hindus would not be covered by the concept of race. They are faith communities, pure and simple, and it's a little different for the Jewish people. We don't fit neatly into those other categories, but because of the way that our history is unfolded and the way that our identity is constituted, we do come within the definition of race as an ethno-cultural community, not as a faith community.
So how about if you had a community of people who have converted to Judaism? Are they still going to be protected by that definition?
Yes, because they are part of the ethno-cultural community. And also, as it so happens, if they've converted, they'd be part of the faith community too. But it's not one or the other. We don't compartmentalise between faith and ethno-cultural identity. If you convert to Judaism through a religious process, then you become part of the community in its totality and in every sense. So it would encompass the ethno-cultural, linguistic, the Hebrew language, the Hebrew culture, everything that goes with it would be part of that.
Okay, well, that's terrific. I was keen to understand if you're satisfied with that definition, given that, we're trying to address anti-Semitism in Australia, and I'm not sure that those who are perpetrating anti-Semitism would make the same distinction that you've just made there. So,
fortunately,
thank you.
Fortunately, the perpetrators of anti-Semitism don't get to mark their own homework or self-assess. It has to be assessed on objective factors, and there is a long line of legal authority, of jurisprudence, and many other factors that establish that the Jewish community in Australia is covered by the concept of race.
And we are making a proposal as well regarding the sentencing aggravating factor as well to ensure that it includes a mistaken belief that someone is a member of that ethno-cultural group, because obviously a lot of the incidents that we see reported to us involve individuals who have been targeted on the basis of a mistaken belief that they are Jewish.
Okay. Finally, the Prime Minister has used the Old Testament as an example in previous days, and yesterday 3 times he used the Old Testament as an example to justify why he's put the religious text exemption in place. Are you concerned by that linkage?
Look, I think it was a very unfortunate trope. I'm not for a minute suggesting that the Prime Minister would have done that intentionally and with that understanding, but it just illustrates the point I made earlier about the general ignorance in the wider community about who and what the Jewish people are and what anti-Semitism is. And the Prime Minister's probably just reflecting a much more general misconception and set of ideas by doing that than one might think. Look, every faith community can point to religious texts which have been used or could be used and construed to promote hatred on the basis of race. And yet every single one of those world religions, if you consult the major religious authorities of those religions, will tell you that that is a misreading of those texts. Whether you're talking about the Old Testament, the New Testament, the Quran, or any other religious text, the leading thinkers and figures and leaders of those religious traditions will tell you that that's a misreading of their text, and that whilst some people in their ignorance have misinterpreted them as promoting racial hatred, that is not their true meaning, and in fact it is directly contrary to their meaning. I can point to passages in the New Testament about about Jewish people. I can point to passages in the Hadiths and in the Quran about Jews which have been misconstrued in that way. And that's the point of this legislation, where and why the religious exemption is so misconceived, because that's not what the religion says. And where a person uses a religious text as an excuse to intentionally, deliberately, knowingly promote hatred on the basis of race against other people, that should be prescribed, right? Religion should not be an excuse there, because, racial hatred in our own time is abhorrent and should not be intentionally promoted under any circumstances.
And we have international law obligations as well in that area. So, there shouldn't be an easy out for any pretext for promoting racial hatred in Australia today.
Was the usage of the Old Testament offensive yesterday? And would you publicly advise that politicians don't use that as an example going forward?
It was ill-advised, and if our advice had been sought about it beforehand, we would have advised strongly against it. And yes, many people in our community, frankly, did take offence. I've had a number of communications about that. But I'm not saying that it came from a malicious or a malevolent place. It's more out of ignorance than anything else, and it's a widely shared ignorance.
All right.
All right.
Thank you very much.
Thank you for your time this afternoon, and thank you, Chair.
All right, thank you very much. And look, I just wanted to clarify something from earlier. I think it was Simone, you mentioned in your evidence to, I think, Senator Dunham, just about the hate crimes bill and the consultation. You said October last year. I'm assuming you meant October.
Sorry,
2024. Yeah, that's all right. Yes. I think we all make that mistake in January. That's all good. All right. Well, look, on that note, can I just say thank you very much again to you, Simone, Peter and Anita, especially on the short notice to appear before today's hearing.